please come forward and speak a few words. Thank you so much. A big round of applause for Suresh sir. We had been missing you for last few months. Thank you so much.
I don't need an applause, really. It's good to be back in Dubai. I literally arrived last night, late last night, thanks to, seeing the picture of my friend, Mr. Siddharth Balachandran. I said I can't miss it. So, the picture was very good, but in reality, you're better, actually. Thank you all very much for attending this breakfast session. It's been working well for the last 7-8 weeks, possibly because of my absence from here. So I was remote, directing Sibi and Ajit, and I think they did a splendid job over the summer months when we had quite a few of these sessions, panel sessions in particular. I'm never sure whether breakfast is the best format or lunch or dinner. Dinner obviously pulls the largest crowd, and dinner with drinks pulls even larger crowds. So, we're still trying to figure out which is the best time of the day. So, one of the thoughts that I left with, or will be leaving with Sibi, is to check with each of the members as to where they are located in terms of their office and residence, so that we can try and arrange it as close to as possible. I myself spent nearly 30 minutes on Happiness Street, and I was telling someone, happiness is the last word that comes to my mind. When I'm sitting in the back of the car and, it's a gridlock of traffic. But it's all about enforceability. I was just reading Sheikh Mohammed's words there. Imagine it, design it, and then implement it, execute it. All of that is very good, but in days when things get tough, it's the enforceability of the contracts that come into fore. And these days could be regarded as tough times. But IBPC members are tough themselves, so as they say, when the going gets tough, the tough get going. And one way to do it even better is the enforceability of contracts that come with it. My own experience over 45, 48 years in the banking and financial sector would suggest that many of us sign agreements, and at the time of signing agreements, it's usually done in a climate of happiness, trust, confidence, positivity, optimism, and everything else. And sometimes we fail to read the small print. And all of these things come to haunt when you have to enforce it, and that's the time when we pore over the documents. The documents are the same, but as we interpret it, some meanings are different, and I'm sure our learned friends today in the panel discussion will touch on this more. I don't want to steal their thunder. So without further ado, back to you, Sibi, and thank you all once again.
Thank you, Suresh sir. For the session, we have an illustrious panel of speakers today, Mr. Atik Anjarwala, Managing Director, AC&H Legal Consultants. He has been a senior partner with Anjarwala and Khanna Advocates, Kenya's leading corporate law firm and managing partner of AC&H and Legal Consultants in Dubai. And we have Mr. Peter Somek. He's the regional managing partner of DLA Piper in the Middle East, a role he has been on since 2015. And his remit as regional managing partner, he oversees 9 offices, over 200 staff in UAE, Saudi Arabia, Bahrain, Kuwait, Oman, and Qatar. And our next eminent businessman in the panel is Mr. Siddharth Balachandran sir, Executive Chairman and CEO of BBM Corporation. The session today will be moderated by Mr. Vikram Venkatraman, Managing Director of Vyanta Advisors. The format today we're going to follow is, we'll have a short presentation, which will be followed by panel discussion. So further, I'll just welcome Mr. Vikram Venkatraman sir to please come forward and brief us about the session today. Please welcome Mr. Vikram. Thank you so much.
Thanks, Sibi. I think Suresh has done the honors. He's given us the background and the setting for today's panel discussion and the presentation. Last time we had this event, it was on finance and banking, and it was about the credit crunch, etc. So being one of the pillars and one of the oils that fuel the engine of the economy, finance was critical, but we also are acutely aware of the importance of the judiciary, as Suresh touched on, and the role of law. To bring an international perspective, we have Peter, who's with an international law firm. Also, Atik brings his own international experience, having practiced and worked in the UK, as well as running one of the biggest law firms in Kenya, probably the biggest, with multiple offices in Africa. So these two gentlemen will bring an international flavor and a comparative, maybe make some comparative comments between the enforceability of contracts, etc. here, as well as in the other jurisdictions. Siddharth and I will probably focus more on being at the receiving end of this subject, and I will also make some comments as to what I have seen from my years as a banker, as Suresh is, of course, and how businesses have been affected by the enforceability of contracts. So may I request the panelists to come and have a seat, and then Atik to make the presentation, please. Thank you.
Good morning, everybody. Thank you very much to IBPC, to Vikram and Sibi for inviting me and for arranging this morning's event. As has been pointed out, this is a really, I think, a pretty critical topic for anybody who's doing business in the UAE, but of course across borders as well. Apparently that's me, so you can decide if it is me or not me. Okay, so let's start with the main question, if I may, maybe you can just a quick poll of everybody sitting in this, in the room today. What is your experience? Is poor enforceability of commercial contracts in the UAE affecting business? If the people who think it is, can I request you to put up your hands just to get a feel? And the no's? Okay, so I think it's an overwhelming feeling, I think, across the room that clearly there is an issue. Okay, and I hope that my fellow panelists and I can try and help you through some of the problems that businesses face. What I will try to do is be very practical. Please rest assured, I won't put you to sleep, hopefully, in the first 5 minutes being a lawyer. So what I'll try and do is just flesh out things that I think are very critical when you're making contracts, and also points to consider in the event, God forbid, you have to enforce your contracts. And I think some of the challenges that, and those of you who unfortunately had to face going to court, for example, or arbitration in the UAE, some of these things, may be very relevant to you. You will have experienced these. But what are the causes of poor enforceability? So cost and language, obviously, right? So I think we all know that going to advocates and good advocates in the UAE is expensive. So it's something you need to keep in mind. We have 3 levels of courts in the UAE. You can pay heavy translation fees. And certainly we find that this is often a bar to people even starting proceedings, especially if you have small debts to collect and multiple small debts to collect. Then what you will pay in court fees, what you pay to advocates can often put you off actually starting legal proceedings. Lack of local assets to satisfy court awards. I think this is clearly a very critical problem that we are finding across the UAE, and it links to a couple of the other points that I raised in the slide with flea risk and travel ban. So we all know, sitting here, that when it gets rough, people leave, right? And I'll be explaining slightly further down the list as well that there are unfortunately very few steps that you can take to enforce somebody staying in the country, or enforce stop the dissipation of assets, because the legal system is weak in that regard. So again, I think when you're making your credit assessment of a customer, when you're thinking through how would I enforce a contract in case there's a default, these are things to keep in mind, okay? People talk about travel bans. I've heard this used quite loosely. It's actually quite hard to get a travel ban on somebody, unless there's a criminal element that you can show. And normally in normal commercial contracts, to show a criminal element is quite hard unless you can prove some sort of fraud. In civil claims, if the numbers are big, and if you get a first instant judgment in your favor, then you may be able to get a travel ban. But again, it's very discretionary. And in my experience, it has to be quite a large figure, 10, 15, 20 million dirhams over, before you can even ask the court after you win in the first instance to try and get a travel ban to stop somebody leaving. Dissipation of assets. So, in many jurisdictions, India, the UK, the number of countries in Africa that we have, if you, in knowledge of your credit position, start moving assets to your wife, for example, or to an offshore company, there are normally what lawyers call clawback risks, where the law will give the creditor rights to pull those assets back because they were not transferred for a bona fide reason. Those sort of laws are sort of lacking in this part of the world. So again, the way that people can move assets when they're getting into trouble, again, makes it hard for you to find the pool of assets that you can go and execute upon in the event that you succeed in your court case. Failure to meet execution formalities. I mean, I'll touch upon some of these, as I go through my presentation. But there's some very simple mistakes that people make, simply because I think of lack of knowledge about the legal system here. And most of us in this room, I suspect all of us in this room, are actually expatriates. So we come back with our history of our home jurisdiction and the way contracts are prepared there. So, please remember that as far as UAE law is concerned and UAE contracts are concerned, the legal system is actually very different from the English common law system that I think most of us are used to. So it's a very formalistic system here, which means that, believe it or not, having a rubber stamp on a document to say it's authentic is critical. Whereas in most Western countries, or the countries which have common law systems, it's not relevant. As long as you show that the director signed the contract, prima facie, that contract should be enforceable. I think most of you would be aware that the way the court system here, there's no oral evidence that you give, so you don't go before a judge and you're not cross-examined by a barrister or by an advocate. So it's very paper-driven. Paper-driven means please keep good records. It's really critical. Okay, we've seen so many cases where, but I spoke to him on the telephone and he confirmed this to me. Okay, now, if you're in front of a judge in India or in front of a judge in the UK, you can be cross-examined on that, and the judge will either believe you or not believe you that you had that conversation. Okay, but here it doesn't work that way. So making sure that your paper trail is strong, okay, and that you have all your emails, all your letters, properly filed is actually very critical, because having that hard evidence to compile and put before the advocate to bolster your case becomes critical. It's a very procedural system here. Okay? Those of you who have been through litigation will have known the role of the expert. I actually forgot to put it on the slide here, but that's a very critical point in my view. And you will probably have guessed that if you fail before the expert, there's a high chance you'll fail before the judge. Okay? And against what I found, a lot of people don't put enough energy at the expert stage. So ensuring that you are tactically aware and that your lawyers are tactically aware of how to deal with the expert becomes very important. Because if you convince the expert that your position is legally sound or otherwise sound, it's going to put you in a much better position. So I think a lot of energy should be placed, that you will place with your team, should be at that expert stage. It'll take you very far. In terms of anti-Sharia, I mean, again, there's a lot of sort of theory flying around, right? Everybody tells me that you can't charge interest on the loan in the UAE because it's anti-Sharia. That's actually not true. Okay? Private loans you cannot charge interest, but if you are a commercial entity, so if you're an LLC or you have a professional license, and therefore you are licensed by the DED, and you lend money, you can charge interest. Of course, there are rules against usury, okay? But your standard interest you can charge. But if you're giving your friend 1 million dirhams as a friendly loan, and you have a little agreement, and you say, 10% interest per annum, that will not work. But so, again, I'm raising these points, just small points to keep in mind as you are discussing or considering a contract. Sovereign immunity, not a very big issue, but those of you who are dealing with government entities here, just keep that in mind, that government entities enjoy sovereign immunity, which is difficult to sue them. And in most cases, you'll need to get the local ruler's court approval before you can take legal action against them. So again, just in terms of doing your credit analysis in your mind, if you're dealing with a government entity, you need to be very careful. Legal uncertainty, again, the legal system here is very different. It's a civil law system, unlike the system that most of us are used to. So you don't have past court cases, what we call precedents. Most of you must have heard of that, in terms of say, okay, this is what the law is going to be. So you could have pretty much the same facts, and a judge in Abu Dhabi is saying X, and a judge in Dubai is saying Y. And just the way it goes, okay? We do rely on past cases, but they're helpful as opposed to having sort of real weight in court. I've touched upon costs. So remember, in India, in the UK, if you are a losing party, okay, you pay a substantial amount of the winning party's legal costs, okay? Here, that's not the case. If I'm not mistaken, it's like a couple of thousand dirhams that you'll get maximum. So but the point is here that the cost of litigation becomes heavy. So if you prepare your contracts well, and if you can avoid many of the pitfalls, then a lot of these issues that I've pointed out as sort of weaknesses, and I guess I can see a lot of people nodding their heads because perhaps sadly people have gone through this experience, you will avoid. Okay, so it's just trying your best to cover some of these risks and being well prepared. And then lastly, it touches upon the flea risk point that I mentioned. That it's very hard to get injunctions like you would get in the UK or you would get in India to attach assets before judgment, and keep that in mind. Unless the proof of flea is very, very high, to convince a judge to attach before judgment is very difficult. So if you take the normal cycle of a first instance litigation, which is, say, 8 months, in the meantime, Mr. X or Mrs. Y has taken the assets and either sold them or put them into somebody else's name, and therefore, high chance that beyond your reach, if after cassations, you actually win. And again, I think that's something that in doing your credit assessment, in just thinking through who is my counterparty, these are some of the points that I think you need to bear in mind, because these are the challenges that you will face. And regretfully, I've had cases of being very successful in ultimately winning a case, but obviously no point if that's just a paper judgment which I can hang on my wall, but if it can't actually attach to something and give the client value. So having sort of set out many of the challenges, I thought I'd just try and identify some of the mitigating factors. And I said, my aim is not to be legalistic in here, just trying to guide you and hopefully make you realize some of the fairly straightforward things that you could do, before you sign a contract. And for the lawyers in this room, and Peter is here and a couple of others, hopefully when you come to your law firm, to help you put that contract together. So obvious stuff, right? Put some KYC on the counterparty, and I'll touch a little bit on that. The very obvious stuff, right? Get a copy of the trade license, for example. Who's your counterparty? Because you say XY LLC, but actually the trade license says ABC LLC. Okay, so who is your contracting party? Okay, have a valid written contract. Okay, so as I explained earlier in the UAE, this notion of but I told him this, or here are a couple of SMSs, they can help, but it won't, the evidential weight won't be the same as if you were in a court in India, for example. Consider key contractual terms. Of course, this applies everywhere, but what I found here that there is still this concept of good faith, and and I'll touch again on a little bit in much more detail, but I just wanted to put some of the key themes here. And then, where the contract matters, please seek some legal advice. Okay? Because hopefully your lawyers will point out some of the key weaknesses or some of the key legal and commercial points that should be in the contract, which are not in the contract. Okay? And that should hopefully then help you in terms of coming to, to be in a strong position. So who is your counterparty? And I just touched upon that. Is the person of, is he a person of means? So your very good friend is well known to, have a very substantial business, but actually the counterparty to the contract is a JAPSA offshore company, okay, with nothing in it. Okay? So if it really becomes rough, you'll be suing the JAPSA offshore company with a basic share capital and no assets. Okay, so who's your counterparty? And we've seen this, I've seen this many times, acting for, on the other side against some large corporations where a little SPV is created with that name. But remember, your credit risk, if things go hard or go difficult, is just that little shell company, which has got nothing in it. Okay? Authority and capacity to sign. Again, please remember that these jurisdictions are very formalistic in how they work. So I'm sure all of you have gone through the notarization procedure for offshore documents, for example. You see how formalistic it is. You have to get it attested and notarized, and then Ministry of Foreign Affairs. So again, basic stuff, but important stuff. Make sure that the person signing has the authority. Is he the GM? Okay? Look at the memorandum of association. Does he have powers to sign that? Because that's your classic defense that we brought against you, that he didn't have powers to sign this contract. Okay? So as I pointed out here, in the case of a UAE company, and again, I'm trying not to be overly legalistic because there are obviously nuances to even what I put on this slide, but basic stuff. Is there a power of attorney to sign? Is there a shareholders resolution to sign? And the law is very unsettled on this, but again, it's a slightly technical point, but where you have an arbitration clause legally is seen as a separate contract within your main contract. And there are conflicting cases in the UAE on whether a specific power to sign an arbitration contract should be in the power of attorney or in the shareholders resolution. And there are cases that go one way and cases that go the other way here. So what you might find is that the defense brought against you is that actually the arbitration clause doesn't work. So now where do you go to actually fight your case, right, if the arbitration clause does not work? I think I pressed the wrong button. Oh, here we are. Okay. Okay, so I mean, just on the KYC point again, and I think what I tell the clients is, well, that if they come to me to start reviewing their contract, these are the basic stuff that I would ask them. And obviously it helps us a lot if this information is forthcoming to us, okay? Get a copy of the memorandum of association. Make sure it's the latest copy. Confirm whether there are any restrictions on the general manager's power. So it says what we have sometimes for foreign clients, they'll have their GM here, but they want to limit his rights to sign certain things. And the memorandum will expressly say that he cannot sign a distribution agreement, or he cannot do X or cannot do Y. Now, if he signs that contract, it's invalid, because he didn't have the power to do it, okay? Obviously, do a search, get a certificate of good standing from the DED. Is the company's trade license up to date at the time you sign the contract? Some basic KYC documents, okay? Which I put up here, Emirates ID, a copy of the visa, a copy of the passport. Just make sure that that person is of the right standing and has authority to sign. When you come to non-UAE companies, it's slightly more complicated. And you see the first point I've put here is that seek appropriate legal advice. And the reason is that when it comes to a contracting party and its ability to enter a contract, that is dependent upon the law of that country. Okay, so if you have a Japanese counterparty, or you have a Kenyan counterparty, or you have a Sri Lankan counterparty, how that company is entitled to sign contracts depends on the law of that country. So often it's worth spending $1,000 going to a law firm in that country and saying, just confirm to us that this company in Sri Lanka has the power to sign this contract. Is there anything in its constitutional documents that restrict that? Because you might just for not touching that one point, your entire contract could be set aside. Okay? Some of this stuff, I think most of you will probably appreciate it's actually quite common sense, but I've just seen so many cases where, it doesn't happen that way, okay? And now, especially in the UAE, we have one written contract with all the terms in it, not 7 emails trying to make up a contract. In the UK and India, the contract law is much more flexible, and a court will read into one contract, using all those emails, or you can have that argument at least. In the UAE, it's much harder, okay? There's some basic, and again, I'm trying to avoid to be too legalistic, but some basic essential elements to make a contract valid in the UAE. So there has to be mutual consent of the parties, which means that, get board resolutions or get shareholder resolutions to show that both parties consented to this. The second point, permissible subject matter, and that is possible to be defined. I mean, these are based on some Sharia principles that like to do with future contracts. You have to be quite careful when you deal with those. Not really a problem for most standard contracts that you'll enter into in your business. And of course, there are again sort of the core of your contract must be lawful. Quickly just turning to some validity issues. Again, hopefully, if you take this slide away, just useful for you in your office just to keep. So some very basic when you do a written contract, basic formalities to keep in mind, okay? The manager should ideally state his capacity when execute the contract, signed by Vikram as general manager of whatever, Vianta LLC, for example, okay? Put the company's rubber stamp on it, really critical, okay? Remember, if an individual signing a contract, of course, he can sign under his own hand, his own signature, okay? Remember, certain contracts must be notarized. I mean, I think most of us will probably know that, but like a power of attorney. A power of attorney which is not notarized in the UAE has no validity. So I've seen powers of attorney, made on the computer, Vikram giving me a power of attorney to act on his behalf. Actually, I can't use it. And if you think that you have the power of attorney in your hand and he's left the country, nothing you can do about it, okay? So just make sure that the formalities for certain unique type of agreements are actually followed. And remember, as far as powers of attorney are concerned, in the UAE, under UAE law, they die when the giver dies, right? So you cannot use it post their death, unlike the UK where you can have powers of attorney that survive death. Okay? So again, in your credit analysis, or you're thinking about a contract, if I have a power of attorney, if the giver passes away, it falls, okay? And then there are certain type of contracts where certain formalities have to be followed by law, again in the UAE. So commercial agency agreements, we know that they could require registration, et cetera, for them to be valid. So just keep those sort of points in mind. Because all of these will actually affect your ability to enforce. That's the point, okay? What I've done here, and this is the last sort of side of substance, because I know the time is very limited, and I'll get into some of the enforcement issues then. I've just put down here some, what I thought are like key points that try and have in most contracts, okay? A lot of this stuff is quite in common sense, but let me add a little bit of flavor, and hopefully you'll see why we as lawyers get excited or get depressed, depending which side of the fence we are on when a client comes to us, right? So price, okay? I mean, think about it. Like currency, is it a dirham payment or is it a dollar payment? Significant difference, right? What are the payment terms? Is it quarterly? Is it annual? Is it semi-annual? Okay, payable in advance, payable in arrears. It should all be in the contract, right? You should be saying all of that stuff. Not that, but you said you're going to pay me the first of the month. But I thought, no, I said the end of the month. That's 30 days gone, okay? And if it's not written, it won't work. But basic stuff, okay? Warranties as to quality, for example. What are you demanding? And I'm being a bit careful here because UAE law has certain implied obligations under the civil code. But again, keep all these points in mind, okay? Delivery periods. Where do you deliver? Is it at my warehouse? Do I pick it up from your warehouse? Okay? Force majeure. Now, this is something that I find is an inherent misunderstanding by most people. People say this contract is subject to force majeure. Doesn't mean anything. UAE law does define it somewhat, but there were many famous cases. If you all remember the famous Iceland volcano incident, you all remember that, right? There were many cases in the UK courts coming out of whether that was force majeure or not. Was it an act of God? Okay? So the thing is with force majeure, identify what you actually mean. And depending which side of the party fence you're on, you want to identify it. So if you are going to be getting a supply of something from India and supplying somebody else, if there is a labor dispute in the seller's factory, is that a force majeure event or not? If the person you're buying from, if it's a problem in his factory, why should it affect you? Right? But if his lawyer is smart, he will have written there any labor issues is a force majeure. And your answer should be back, well, if you're not managing your labor relationships properly, why should it be my risk? It's your risk. So, but if that wording is in there, you suddenly don't have the same wording in your onward contract, so now there's a mismatch. Because he doesn't have to supply you legally, because he's claiming force majeure. You don't have that force majeure clause on your onward sale. You see the mismatch now. So your ultimate buyer is going to say, listen, you are in breach, termination, or whatever the consequences are of that. Okay? Limitation of liability, it is possible under UAE law. Slightly more complicated procedures under English law. But again, think about it, because I've seen so many contracts where the person performing has not tried to limit his liability in any way. Therefore, what are the type of losses that the other party could claim in case of a default? Is it just the price? Okay, is it loss of business? Is it loss of reputation? So on and so forth, right? So what you think could be a 5 dirham claim could become a 20 dirham claim at the end of the day, if you haven't limited your liability. Confidentiality can be important, okay? There are often contracts that you don't want to be coming into the public domain. Interest, again, I've seen this all the time, right? I mean, the most basic, is it flat rate? Is it reducing balance? Is it compounded? Is it annual? Interest rate is 6%. As a lawyer, it's a field day for me now, right? Depending on which side of the fence I'm on, okay? Just very, very simple stuff. It helps us a lot in the event that you're going to be in a dispute. Termination again, okay? What are the grounds for termination? Let's think this through very carefully. And it could be very, very important for you, depending on the size and the nature of the contract, okay? So, is it just payment default? What if you know the other person has defaulted on his bank lines? Should that be a right for you to terminate early? You want to probably think about that, right? Because if he can't pay his bank, how is he going to pay you? But if you don't have the rights of termination expressly stated in your contract, you can't terminate, for example, okay? If the person doesn't get his license, his trade license renewed, should that be a ground for termination? So again, just think through who is your counterparty, what are the types of termination rights I should have, and of course, the lawyers are trying to sell themselves here, but the termination rights also need to think them through unique to your particular type of contract, because the circumstances and the counterparty could be very unique. Okay? And then law and dispute resolution. So that's the last couple of slides that I have, and I know I'm actually now getting a little bit out of time, so I won't spend too much time on it because a lot of this is actually quite technical. But I think you all have these slides with you, so just keep them with you, and hopefully there'll be a good point of reference. But I'll just spend a couple of minutes just to pull some of this stuff out. Okay? So, and I was just talking to somebody earlier at breakfast. So I had a client who came to see us, had a distribution arrangement with a Japanese company for almost 30 years. Spent a lot of time, energy building up that name in this market. Okay? For various reasons, the Japanese came and terminated with 1 month's notice after about a 30-year relationship. Very un-Japanese, I know, but that's what happened. Okay? So they came running to us and saying, this is unfair, it's so harsh, and I've worked all these years to build up this brand, et cetera, et cetera. The first thing I did is when I opened the contract, we saw it was Japanese law with Japanese arbitration. Yeah? Because I don't think they bothered to read the contract, not to understand it. Nothing I could do to actually help him. All I did was put him in touch with a good Japanese lawyer, and they're still fighting the case in Japan. The expense, the time, language, et cetera, et cetera. So, of course, putting your governing law is the most important point. If you don't have a governing law, then you have a big problem anyway. So what law governs your contract? Is it UAE law? Is it a foreign law? And of course, remember that within Dubai, certainly, you don't have to be a DIFC party to have a DIFC law contract or an English law contract where you will fight your case out or you dispute out within the DIFC. And that can be quite helpful because to the extent that UAE law is unclear or is not sufficient to meet the needs, then you have the English law fallback, which we all know coming, from being our mother law from India as well. It's very flexible and gives you lots of ability to actually move around and maneuver on contracts. But that means that, it gives you more rights and also enforcement rights because you can actually enforce within the DIFC and then with the local courts as well because of the memorandum of understanding that exists between the DIFC and the local Dubai courts. So the whole question of law, what is your governing law? Because if you have a Japanese law contract, then most of your terms in the contract will be subject to Japanese law anyway. Right? Now, if you ask me to read that contract, what am I going to tell you? Even if it's in English, because I have no clue what Japanese law says on termination, on indemnity, on interest, on pricing. I have no clue. Okay? So that means I would need to involve a Japanese lawyer to actually advise us on what this actually means under Japanese law. So, and I understand that sometimes you might be dealing with a big multinational and you don't have the strength, the commercial strength to make them change. But the point is that at least in terms of your own risk analysis, right, you should be able to know where you stand. So like the client I mentioned, he spent 30 years building up this brand, right? He could possibly have argued with the Japanese that, listen, you give me X budget every year to advertise you guys here and to build your brand here. Okay? At least he would have saved that cost that he spent 30 years of wasted cost because that contract went away. And remember, there are certain type of contracts that can only be subject to UAE law. For example, employment, distribution contracts. And again, I've seen some very interesting variables on this. People putting law of India on an employment contract. So you won't be able to enforce it here, clearly, because the local law requires that it must be under UAE law. Do I have some time, Vikram, still? A minute or two, okay. Okay, so just, again, very quickly, because I think this is quite technical, but again, it just turned upon the point that I touched upon earlier. Just think very carefully or discuss with your legal team the law and what is the best forum in the case that you have to enforce your contract. If the counterparty is in Dubai, then your choice is the DIFC courts or the UAE courts, the local courts. Now, which makes more sense? If you have a foreign party, right, what is the best forum to sue? We all know that Indian legal system as well is very complicated. Okay? And I know that you can be 5 generations and you still haven't come to a conclusion. So would it therefore make sense to have the dispute resolution in Dubai, okay, with the ability to take that judgment or that arbitral award from Dubai and register that in India? Okay? Because we know that the DIFC courts, you're able to get an answer within, say, 12, 18 months, as opposed to 18 years. Okay? So should I take that judgment from Dubai and then go and enforce that in India? And how would that work? So these are some of the tactical things that you just need to keep in mind depending on your contract. Of course, I understand if spending the type of time with lawyers, etc., would mean that the contract has to have that value, but keep these points in mind. I think they'll hopefully help you when it comes to, in case there's any dispute. I'll just mention this conduit jurisdiction. You've seen that there. So as you know, the DIFC is very hungry to be relevant, okay? And what has happened is the DIFC has signed a number of memorandums of understanding with other courts. So they've signed with the UK courts, Australian courts, Uzbek courts, Kenyan courts, Zambian courts, where they have agreed to recognize money judgments between themselves. Okay? That's an advantage and a disadvantage. Okay? So the advantage is that if you are dealing with a Kenyan counterparty, arguably have your contract under English law with the DIFC, and if you win, you have de-risked yourself from the Kenyan courts. The flip side is, you have a judgment against you in London, and you take the view that I'm sitting in Dubai, nobody can touch me, be careful. Yeah, because they could bring that London judgment, bring it to Dubai, and enforce against you. And I've seen this happen quite often, that what's the guy going to do to me from London? I'm sitting in Dubai comfortably. So generally those days are now limited, by and large anyway, but just, that's why I wanted to just raise the point on the conduit jurisdiction. And that's the plug for the lawyers. Thank you.
Thank you, Atik. A lot of food for thought there. A lot of more unanswered questions than answers, naturally. It can be scary navigating the legal system and navigating contracts and protecting yourself. But that's what it is, and that's the system we have to operate under. So we'll have a brief panel discussion followed by question and answers if there are any questions. Let me go to Siddharth as a businessman. After the presentation from a lawyer. Siddharth, as a businessman, what is your view of this issue? I mean, obviously, you must have been impacted by this at some stage or the other. Has it been an impediment? And if the answer is yes, how serious has it been? I mean, the enforceability of contracts. How, as a businessman, have you mitigated this in your various businesses? I know you run multiple businesses.
Is my voice audible?
I think you need that.
Now, see, thanks. I think it was a very interesting presentation. Thank you. The perspective I'd like to give is, let's face it, we are in the land of unbridled option. Unbridled option. I think this is,
I think, Siddharth, you need, yeah.
I underestimated myself. Clear? So, what happens in such overwhelming optimism? Let's face it, even the most diehard of a pessimist, when you land in Dubai, automatically you sort of feel that surge in energy, which is a good thing. But the point here is that whatever you do, whatever initiative you have, the intensity should always be matched, reinforced, or tempered with purpose, with clarity of purpose. So Vikram, to answer your question, I wouldn't call it an impediment because you face it daily. But what I would say is it's a challenge. Now, how you can make the challenge work for you is very simple. I think the last line, which Atik had written on his slide, solicit advice, pre-deal. This is very important because a lot of us are carried away with the temptation of possible success, possible stupendous success, that we forget about, as Suresh said, the fine print. The fine print should be inside you in the sense that you should ask yourself as to, for what purpose am I getting into this contract? So this is what I ask myself every day. If there is any deal on the table which looks extremely good in the short term and probably in the long term as well, the first question you should ask yourself is what value, what purpose you are achieving by getting into that deal. The second thing is, don't let what I do, this is again entirely my opinion, each of us have different ways of working, this is mine. When you treat it as an impediment, automatically what follows is static. It sort of goes into hiatus, which I've found in my daily experience is probably more dangerous than not even getting into it. So what I would do is incorporate a system, a checklist, if that makes sense to you, which is quite general, but at the same time very specific, which was what I was remarking to all of you. This topic itself is so general, but the nuance of it is very specific. Ultimately, you are in a place like Dubai, which has a lot to offer. But why are you in a place like Dubai? Because it has all this ease of operation. Along with it comes this. A lack in impetus towards enforceability is something which all of us face every day. You cannot combat it, but you can preempt it. So my thought, which I would like to put out here, is every aspect of the deal, every aspect of the contract should be worked. So even the soliciting, it's not post after a problem happens, pre. So spend as much time as you want, days, months, analyzing that contract, getting advice. And I generally have a rule of, we have 2 lawyers in our retainer. So I get opinions from both. And my thumb rule is if there is a general consensus, then I have crossed the first hurdle. So if there is a disconnect in the opinions of the lawyers at that stage itself, then I think about it.
Yeah, fair enough. Thanks. I think that's a practical approach. Peter, you heard both a little bit of a perspective from a businessman and also the UAE perspective. I think what will bring into contrast the UAE, the issues faced in the UAE, and possibly mitigants to address them, will be a perspective of how this compares with other jurisdictions. So obviously, I think the UK jurisdiction would be a case in point for you. So how does it compare in the sense where you possibly experience a more robust or more predictable judicial system, as Atik pointed out? So in your mind, would you give us a comparative comment, please?
Thank you, and thank you, both of you. I've spent approximately, obviously I'm quite old, so 20 years in the UK, 10 years here. So I've seen both the English legal system and I've seen the UAE legal system. So I don't know what you were doing between 2:30 p.m. and 10 p.m. yesterday, but I guarantee you were having more fun than I was having. I was sitting in a bank looking at another firm running a fraud case, and we were asked to have a look at it. I make that point because the environment here has been explained. There's a lot of opportunity here, which I think is why we're all here, but it's also a very transient population. And therefore, as businessmen contracting, you cannot, if things go wrong, is your counterparty going to be here anymore? Maybe, maybe not. They've probably got somewhere else they call home. So I think against that context, you need to balance your risk. So it's not something that typically you would face in, say, somewhere like the UK, and I thought a very good presentation at the start by Atik, and I think in terms of the antecedent provisions, the ability to get recourse when somebody's left, it does actually exist in the law now, and it's trying to catch up. How effective it is, I think we're going to see over the next couple of years. I have a little bit, most of my work now is actually court litigation work here, so I've sort of morphed from a transactional lawyer to being a contentious lawyer, I suppose. I absolutely endorse the comment that you've got to be very careful how you prepare for these cases and emphasize. We have our most senior Arabic lawyers are at the expert meetings because that's where the decisions are actually made in reality. And I think you can put possibly inverted commas around the term expert. So I think it's up to the people who are presenting the information. What sort of experts do you get? You get auditors. You get, if you're lucky, if it's a finance, I do mainly finance, you maybe get a quasi-finance expert, or you get an engineer, construction expert, depending on the sort of dispute. Sorry, I'm straying slightly from the topic, but your lawyers have to be extremely careful, as you do, so it's really important to get the engagement of the client and to go to those meetings because they will have the information and it's actually fairly determinative as to the results. So in terms of, whilst it is a documentary system, this is the one opportunity where you can speak. This is actually when you should speak because the experts are human beings, they're fairly pliable, they will listen, and you've got to push your arguments forward. I think the couple of other points I would say that are the big differences between this jurisdiction and perhaps some others is the contracts and how they're presented. So it was explained that typically, contracts for the local courts have to be translated into Arabic. Even if you enter into a dual language contract, there'll be a clause that says the Arabic will prevail. Now, some of you will be able to read Arabic, some of you won't. I've seen actually more mistakes being made. You've got very good lawyers who will get the contract right in English, and they'll possibly then go and get it translated into Arabic using a translator. And I've seen more mistakes coming out of the Arabic than I have out of actually mistakes made in terms of the terminology. So I think the translation piece, if that is to prevail, is really critical. So you've got to really check the Arabic translation. And I think the very last point I'd make, and I don't think this is much different here than anywhere else, but I think maybe it's more important here, is as a set of lawyers, yes, often we'll just get a client coming saying, these are the heads of terms, draft me the contract. And, you know, time is short, and sometimes we just simply go ahead and we do that. That's not when we typically do our best work. When we do our best work is when the client and we take the time to invest. So we actually try and understand the client's business, at least to an extent, and obviously deal after deal it gets better. But to actually deliver value, to be able to give actually some, you know, some of us been around a long time, we can possibly, you know, stray and start giving a little bit of insight from a commercial perspective if we see something unusual, and perhaps give a bit better guidance as to what market practice is in a particular industry. But that's really about knowing the client's industry. It's about knowing a little bit about the client's business. So I think that I find it a very exciting jurisdiction to work in, but possibly more challenging than some of the more mature jurisdictions.
Yeah, thanks, Peter. I think what's coming out of this whole discussion is the basic difference between this legal system and any other system that we are familiar with. I think most are Indians here, so they would be familiar with the Indian system. We'll have a perspective from Atik. I want to ask him about the other jurisdiction he's practiced in, which is Kenya. But the difference between what we perceive the role of a judicial system to be and the one here, the vast differences, I think, is the one area we need to be really alive to. It's one thing to be part of this great unbridled optimism, as Siddharth put it, and to grasp all the opportunities. But I think sometimes we see an uglier side of Dubai or the UAE or the Middle East where people come for opportunity. Is the more capricious, is the more grasping lust for deals and for money, and the ability to actually, for want of a better word, shaft a business partner because the enforceability is poor. So you get very often badly treated, poorly treated even by somebody you've been dealing with for years because they probably have an edge over you. They know the legal system is not what it is that you're used to. So the differences, and I think the dubious role of the expert, which we have seen when I worked with a bank, with ABN AMRO Bank, how, for example, a debtor who owed money to the bank, it was a bad debt, and there was this expert who examined the documents for 10 years, at the end of which the bank had to pay this man, the debtor, the bad debt, money instead of the other way around. I mean, it boggles the mind. But this is a role of the expert was quite, couldn't understand it, basically. So that is one difference. And then the basic, very fundamental difference of the implications of this language translation, which Peter pointed out. These are things that we don't even think about when we look at a contract or imagine the legal system, for example, in India. So I think these differences are something we need to be really alive to. It's not what we are used to. And I think when we enter a contract, we better think long and hard. And I want to ask you, Atik, as to your experiences in Kenya, for example. I know the Kenyan system is the English common law system. And you have in the UK, which is perhaps the most developed in terms of judiciary and the rule of law. So what is your view and comparison between, say, the UAE and the Kenyan system and your experiences in Kenya?
Hello, is that, can you hear me? Yeah. I'll answer that, Vikram, but I just want to add just one or two points. And again, please don't take this the wrong way. It's not a plug for Peter and me, but you know, one thing I've come across, the world is getting very sophisticated, okay? And the sophistication of contracts that I've seen coming out of India, out of East Africa, out of the UK, sometimes you don't see here, but they are getting more sophisticated. And I think just because of the nature of the UAE, there was a lot of sort of trust element, etc. People signing, when people are getting into arrangements. But, and the consequence of that is that I've seen a transition in my African clients from seeing lawyers as an overhead or a cost, and now transitioning to be actually critical business partners. Okay? Because just the way the world is moving and the internationalization of the world, the way, for example, the US laws on bribery and corruption, sanctions, all the way those laws are impacting everybody, you need people who have the ability to understand this and hold your hand. So I just want to make that, you might see that as a plug for us, but actually it's my genuine feeling that if you just take, it's going to cost me $4,000 to get this done, as opposed to it could actually save me $500,000 if this contract actually is drafted properly, or whatever the figures are. Okay? But yeah, so just to get to your question, Vikram, I mean, we do a lot of transactions across borders, and that's one reason why this office is here. So you'll find, amazingly, many of the African jurisdictions are very sophisticated. Okay, so if you take Kenya, where I work, or Uganda or Tanzania, if you're doing a negotiation, you sort of could be sitting in London, or you could be sitting in a big law firm in Mumbai. Of course, the legal systems are not the UK standard at all. Okay? But you will find that with the large contracts, in any event, people will have arbitration clauses. They don't want to risk the Kenyan system, for example. We've had certainly one big dispute or a contract that we drafted, which sadly went sour, where we already had an arbitration in the DIFC. This was to do with some assets in Rwanda, in fact. But at least we had a place where the dispute could be adjudicated in a sophisticated place, which is the DIFC. So hopefully I'm answering your question, just to say that don't underestimate many of these jurisdictions. They're actually very sophisticated, and your counterparties are likely to be very sophisticated. So and we find this a lot with particularly Western clients going into African countries. The perception is that they're not really with it, but you'll find in many countries they're actually very with it. And if you're not careful about how you have made your arrangements, forget the sort of contractual side, just the business sense of how people run. So as you know, a lot of the East African coast is Gujarati controlled, so I don't have to say much more than that.
Okay, yeah, thanks. I think
Vikram, just one more,
Please.
Something which I'd like to add here. It's an anecdote. It's an anecdote because we weren't affected that much. But just recently, there was an incident. The point I'm trying to make is with regard to the translation. It's very uncanny that you have the English version which states a certain fact. The Arabic version corroborates it. But for want of that particular word, it's not allowed. So, release, the person is authorized to give a release, is directly translated in Arabic. But to our surprise, when we went to get it enforced, the person said that you're not authorized to, but we pointed out, no, there isn't that word which I was expecting. So this is something which I think all of us, the point I was trying to make with regard to the preparation, no matter how prepared you are, there is always going to be that aspect which you've done, but is not enough. So it just corroborates our theory of doing 150% and not sticking to the 100% preparation before the contract.
I think the UAE, as Atik mentioned, yeah, please, go ahead.
Business owner to get my money back at the least cost.
Right.
Thank you.
Yeah, so if someone didn't hear, basically he says as a small businessman, when your average size of debt is small, and you have a legal contract, how do you get your money back without going to court? Well, I can sympathize. I've lost money as well to clients who owed me, for example, an amount like 100,000. Now, it's not small for a small business, but in the overall scheme of things, it's large for any businessman. But even if that's backed by a post-dated check, so in the old days, you had trust and a handshake, on which you did business. Then it moved to post-dated checks. Now, post-dated checks are not worth very much because you can't do very much with them. The police are quite fed up of criminal cases based on. So when you don't have either, how do you get your money back is a very key point because it affects all SMEs below the threshold of what could count as a strong legal case using lawyers. So who would like to pick this up? Peter, please.
I think it's a really good point. So in my law firm, we have probably now 10 court clerks and a number of lawyers. And we tried to make it so that actually we run the court system, the local court litigation, the way we run our other services, as professionally as those. Now, the problem that comes with that is the one you've highlighted, cost. Now, we've split out what we do. We've tried to develop templates to make things as efficient and as cheap as possible so that we can actually take on some of the smaller cases. But I don't think any of us would sit here and necessarily say that you're always going to find a competent lawyer to run a small case, and often the court charges are prohibitive as well. So I think that actually if you're talking 100,000 dirhams and above, you probably can give it a go. Below that, I think it becomes extremely difficult. Possibly better if you are holding it, if you've got some means of filing a criminal case and exert some pressure and do a deal. But in terms of a straight civil case, I think it's a genuine concern.
I mean, but I could just one thought for you. We don't do it in our firm because we don't have rights of audience. But if you have, depending on the number of debts you have, if you have, I can understand that 10, 6, 25, 15. If you can get to a deal with a good local law firm, an Emirati law firm, for example, a young lad who's quite a sort of startup type of firm, and get a retainer with him, right? So that could be the other way. You do a fixed retainer every month, depending on the number of debts that you have, so I've seen that work once. It worked quite well. I just thought I'd give you an idea about how some people are approaching it, because there's no easy answer, as Peter has said. They have the picture.
Attachment itself brings its own problems. I know what you're talking about. What we could see, there is one firm which I'm connected with, which has the same sort of invoice sizes you're talking about, in terms of large volume, low volume, high margin, but divided amongst very, very small invoices. The only optimistic picture I can paint is patience and hope. Why I'm saying that is, invariably, these are people, the kind of people who buy from you are also small, if for want of a better word, sketchy. So the only thing that you can expect from these people is not scare them away. And this is purely a practical perspective. I'm being very, very honest here. It's very easy to say that we'll go to Peter, we'll go to Atik, we'll get it done. But practically speaking, I know what you're talking about. It's impossible. Unless you give them an extended payment plan, you hope to God that you've made that much margin from them that it has an that your extended payment plan pays you back. But more often than not, what we have seen is that the payment comes, but with extreme delay. And with that extreme delay, you lose the customer. So when the stage starts, when the first month is delayed, I think that's when you probably should take the action. If it goes, generally people wait for 2 months and 3 months. We're very nice people here, I think. We wait. So at the 3rd month and the 4th month, we say, okay, fine. Now let's try to get a little aggressive. But that doesn't work. I think 15 days past your payment period should be when the alarm bells start ringing, and then you should start taking action.
Please.
Wafi, and you.
That's very useful. Wafi, you said. Yeah, I think I will go straight there after this.
And a lot of time that carries a lot of weight because the party knows that they are getting a notice from the court. It's a very simple document. You don't have to give details. You just have to say that this amount is due from the other party to you. And in my experience, I have seen like 3 or 4 out of 10 cases are settled because of that. Because they get a notice from court, they are quite willing to settle it. And other option which is more preparatory than when you actually get default is that under DIFC code, there is an option of small causes court. So you could have a specific jurisdiction of small causes court of DIFC, which is for a much lower value transaction. I'm not sure, I think it is $10,000. Peter can correct me. So you could have that jurisdiction clause for a smaller transaction, which is much more cost effective and it goes a long way to settle disputes. Thanks.
So there are two. One is the outlet that you mentioned, the recourse that this small court or the equivalent in Wafi, and one is going directly to the court, you said? Notice to Dubai court. Okay, so these are two useful things for people like you and me. So that's quite useful to know. I didn't know that we had recourse to such things. I wish I had known before.
Ram Tolani from Goodwill Insurance Brokers. I would have comment rather than a question on the word contract itself. It is very important and good to have a contract in place anywhere and everywhere. Thus, chartered accountants and lawyers are required. But I very much agree with Siddharth here that whatever precautions you have taken, even up to 150%, yet there are flaws which may have not been covered. Thus, it is more of a mutual understanding and good faith than the contract word itself alone. Because if we read the conditions of airline ticket, we would stop flying. If we read even the bill of a dhobi, we won't give him a clothes to wash. Or if we read any insurance policy or bank account, we won't enter into any of the contracts with those. So it's more of a good faith than the contract words itself. So I agree very much with, I repeat, with Siddharth, that even if we have taken 150% precautions, yet there are flaws. If somebody wants to make the dispute, there are possibilities.
Yeah.
So contract is more of a good faith than the contract by itself. Thank you.
I think this is a very, very good point, and historically Dubai's trading has been done on this basis. Actually, it goes back to what Atik repeatedly mentioned in his presentation, which is KYC on your counterparty. So KYC can be, documentary is one thing, to check his trade license and MOA, etc. But what he also, there was also indication that one should check about the person behind the contract, his reputation. So asking around, bankers or other counterparties in the business who may have dealt with the same people, is extremely important to establish the reputation or integrity of the person who you're dealing with. So that is absolutely paramount.
You know, Vikram, I just want to narrate one more incident which happened pre-collapse. That is, this was, I think, in 2007. This was a company, a construction company, which one of my subsidiaries used to deal with very extensively. And we're not talking about small amounts here. We're talking about very, very large amounts. 2008 happened, default happened, court case happened. We won the case, attachment happened. And then it surfaces that the person who has signed the contract is the gatekeeper. Can you believe that? So these are the mistakes that you make. You know, under no circumstance, so KYC was done. This was a very, very prominent firm, was a prominent firm during those days, built great, some of the buildings which are very prominent today. But the trade license has a person whose job is standing at the gate and letting people in. Can you believe that? These are things which, when you read it, you laugh and you don't think that this could happen to you. But it happened to us. We got our money, thankfully, but that was more, again, an act of God rather than our...
Force majeure to your advantage. Yeah, no, this is very scary indeed. This is very scary. Peter?
One thing I would say, which is the sort of anti-lawyers thing that I probably shouldn't be saying, but frequently on the bigger deals, people ask for legal opinions. Now, I'm not a great fan of those, even though we make money out of them. I think I absolutely get the point that you check the counterparty, you do the sensible checks, which frankly, I think most people can do themselves if they get the trade license or whatever. But I think when you're engaging your external lawyers, that you'll find many, many exclusions. And I actually look at some of the things that we produce, frankly, and we're no different from other firms, and I think actually how useful is it sometimes. So what I would say is, stepping aside, I absolutely agree, as I would, I suppose, but in terms of drafting the legal contracts, it's really important to get those right, to engage lawyers. But I think in terms of some of the services that you can procure, they're not always that valuable, and you should probably rely upon your own diligence, knowledge, etc. is probably more important.
Thank you. Thanks, Peter. We have time for maybe a question or two. Anyone has any questions? Yes, please, go ahead. Is there a mic?
Yeah, my name is Nimesh. I just wanted to know, often we find that, we have a DIFC arbitration incorporated in our contracts, more of a dispute resolution mechanism. Is it worthwhile to go for DIFC, or should we say go for UAE courts?
I think that's a really good question. We have both functions in our firm because we have a captive local law firm, which is why we can do the local law advice. Now, I was firmly of the view, in a slightly arrogant way, when I first came over here, that obviously arbitration was definitively better and the local courts were inadequate. I've actually changed my view a little bit. I think that there's a few issues. Firstly, I think that arbitration is sometimes prohibitively expensive. If you'll find most law firms, if they win an arbitration award, it goes in the favor of their client. They think it's pretty good, and then they go through the steps of trying to enforce that onshore. If they lose, they'll say the arbitration was inappropriate, and they'll challenge it in that way. So it's not always the case that winning and getting an arbitral award in your favor means you've actually won in any substantive sense. You've still got to enforce it somewhere. So I think for certain types of contract, for example, real estate, you can get, it depends where the real estate is, but you can potentially get award in the DIFC, but you've then got to enforce it onshore. So I think you've got to pick your type of contract to decide actually which is the most appropriate. I don't think it's an automatic given that you go through arbitration, it's going to be more sophisticated, it probably is, are you going to be any happier at the end of it? I'm not actually convinced you always are going to be, and that's, you know, it's a personal thing.
Just to add to Peter, I think in my experience, if you have, as he said, so for example, we do a lot of hospitality work. Okay, so, you know, these hospitality contracts are like 90 pages, hotel management contracts with quite complex formulas on how you calculate gross operating profit and expense, and a lot of IFRS stuff in it in terms of how you so for me, those I wouldn't want to be before an expert in the Dubai courts, because just interpreting all of that would be very difficult. So for those sort of contracts, definitely I would think of another jurisdiction. But I think if your standard supply contracts and your counterparty is in Dubai, then clearly, to my mind, the Dubai courts would make much more sense than the IFC. It also brings your costs down overall.
I think we have time for a last question, Jana.
So, good presentation. I would like to ask two matters from your presentation. One was you mentioned regarding if there is power of attorney person dies, then the person who is signatory to that contract, whether it will be enforceability will not come in because company is signing on behalf of the company. And when he signed the contract, the power of attorney was valid. So then why it will merely because the person who is having a power of attorney said demise of that person, enforceability of the contract will be under a problem? Or I am
No, the answer is no. So if the person signs when he was alive,
correct,
then there's no issue.
Question is,
no. So I guess what I was saying more was that, you know, sometimes people have a power of attorney because they think they'll have a right to sign on behalf of the person who gave it forever. But if that person has died, and in fact here you can terminate a power of attorney. People sometimes take it as security as well, as part of their contractual arrangements. So for example, in LLC companies, sometimes people will take a power of attorney for the 51%. So tomorrow if you want to cancel that power of attorney, you actually go to the notary and cancel it. You can't stop them canceling it.
correct.
If you die, it falls away. So if you try to use that power of attorney after the death of the 51% shareholder, you cannot rely on it.
Just one thing to add to that, because I absolutely agree with that, is the fact that powers of attorney, even if they're expressed to be irrevocable, aren't, apart from in one particular real estate circumstance. So you have to be a little bit careful, and you can, the day you contract, you might want to get that person to go down to the notary and confirm it's still valid. But anyway, just something to watch.
Okay. Only one because you started answering. Another thing was the certificate of good standing from Chamber of Commerce you mentioned. So which areas or when it should be obtained?
I guess so. What I'm saying is that, you know, if you're entering into a contract with an LLC, for example, going to supply them some goods. For me, it's just a question that before you actually sign, just are you sure the trade license is valid? You've got a copy of a trade license. You say, oh, I've got a trade license, but you see that this license expires on 25th of September 2018, okay? And you're going to be signing your contract around that time, for example. On the date you signed, it was never renewed, or there was some problem, or the license was frozen for whatever reason. You could then have a problem because that company was not in good standing. So it's part of your KYC bundle in advance. When you, like we've said earlier, just do some basic check, right? Check that the company is in good standing, for example. That was the only sort of reason I actually mentioned that. Because what we found is people have signed contracts, and then you subsequently find that actually the license was not valid at the time. And it's too late at that stage because the contract has been signed, money has been given, or goods have been supplied.
Thanks, Ati. I have one last question, and then I think we'll close for the day. Is we've all had experiences with various people or businessmen, and if we have suffered for it, and if we, for example, not received payment from a particular person or party or company, and then we find out anecdotally, we ask around that it is a common trait or common trend with this particular counterparty to have done this to several people. So it's happened to me personally in my company, where when I ask around, then everybody, after post facto hindsight, everyone says, oh, this guy's he's done this to others. Now, where is the repository of this information? Now, if we apply to somebody for to the Chamber of Commerce, for instance, for a certificate of good standing, how does the Chamber of Commerce know when to issue a certificate of good standing and when not to, other than if there's a legal or a police case? So is there some place we can write into and say, this counterparty, for example, has diddled me out of money and abrogated a contract, or not legally? No, it's a genuine question. I mean, for example, if somebody is defaulted and you've not been able to claim, and is there some complaint, somebody we can write a complaint to, which becomes a repository of, yeah, it's dodgy, I know it's
I was going to
dodgy.
leave the microphone on the table because it's not possible to answer that question. I actually don't think there is. I mean, as you know, with your finance background, banks are required to report defaults nowadays,
Yes.
and that sort of thing. But, you know, it's a common issue here. Registers aren't open to most people, so I think it is an issue. And it's the same, I think, in, you know, things like there's no open company registry that everybody can search. To search most things, you need the person's permission, who's not going to give it you because they're the person you're trying to pursue.
Right. So that's.
For example, in India, if you want to deal with a company, you can go and check with the company registry.
I don't see.
Winding up petition to file against.
Yeah.
You can't do that here.
Yeah.
There's no bankruptcy registry that you will find in India. You have a credit information.
Yeah, which is still nascent. It's still.
But again, it's not
No,
sophisticated like
no, it's not. No, it's not. Well, I think that was a very useful session. Well, we'll wrap it up. It's already 10:35. I know people are getting edgy. So thank you very much indeed, Peter, Siddharth, and Atik, for your time. And thank you all for attending. We look forward to seeing you at the next session. Sibi, is there?
Panelists to be on stage. May I request President Suresh Kumar sir to please come for the conclusive remarks, and then we'll have a short moment of presentation. Thank you.
I think a quick few closing remarks. I think one is, as Dr. Ram Tolani said and Siddharth had mentioned earlier, there is good faith, after all the legalese and fine print, etc., business is done on the basis of good faith. And one key thing that, in my own experience, is making sure that you're dealing with people that are fit and proper. This is increasingly being used by regulators globally and by even courts, whether the counterparties are fit and proper, so there is a fairly elaborate assessment process in this, and that helps. Before you deal with somebody, you want to make sure that they are fit and proper for that particular type of contractual relationship that you're going to have. Two quick personal experiences. One is with His Highness Sheikh Ahmed, I used the Dubai Chamber of Commerce as an international court, ICC, Court of Arbitration as well, quite apart from the DIFC and the ADGM, which are more recent. And we successfully, won an arbitration. It was a fairly elaborate process because each of the disputed parties in dispute, had to nominate one, and ICC nominated an independent person, and they met physically on the 14th floor, I think, of the Dubai Chamber of Commerce building, and we won the case against Bechtel. It's a different matter. We ended up not paying what Bechtel claimed against us, but that was an interesting one. More personally, there was an educational institution that my wife was running, and the party that bought it arbitrarily deducted certain sum of money. It was not a huge sum of money. It was about 100,000. But I said, as a matter of principles, I'm going to see it to the end. And it was against an Emirati national. And we had an expert appointed who didn't know. He was an Emirati expert. He was hardly going to give a report against another leading Emirati who was a senior Abu Dhabi official. But eventually, he had to be persuaded to meet with the with the various parties and say, look, you have to change your view, otherwise we'll file a case against you. Often the threat of litigation works even better than litigation itself. Once you're in the court, then the matters are all, in black and white, and each lawyer is as good as another lawyer in terms of finding where, the other party is wrong. So I think it's an interesting journey. But in conclusion, let me first of all thank the panelists, for their contribution. It was excellent. And thank you, Atik, for starting with a clear presentation, which set the agenda right. So let me ask Dr. Ram Talwani, since he said some nice words about Siddharth, to come and give a memento to Mr. Siddharth Balachandran. Thank you. He's a senior businessman, insurance professional, and he's been a senior member of the IBPC as well. So in good faith, let them give mementos to each other. Let me ask also Mr. Vivek Agarwala. Is he still here? Do come in and give a memento to Peter. It's good to have people asking questions and offering insights. That's what a good panel discussion is all about. Thirdly, Mr. Nimesh Lokhandwala. To Atik, yes. We can't give two, so we'll give only one to Atik. Otherwise, he was part of the panel and the opening remarks as well. And finally, although there was one more questionnaire here, I'll call Mr. Shonak Reshamwala. He gave some very good insights about the fact that in Wafi Mall, I didn't know about it, and so did many of the panelists, I presume. To our moderator, and thank you, Vikram, for moderating the session in an exemplary manner. Thank you very much. And with Janak Panjwani, I'm going to shake hands for the excellent question. He's also a former office bearer. So thank you all for attending. I think we'll have more of the panel sessions, but maybe change the timings a little bit to suit all of you and more of you of the membership. Thank you.